go to page 37. If you look at paragraph 129, there's an example there. I'm not going to go into it, but you can read it at your leisure, that shows you how Congress has amended the Constitution, and then, of course, the courts pick it up, and they're unmerciful with it. You'll see the principles opposed to it. Now, the next part is page 39. Okay, now here's where it starts to get interesting, because this is the type of case, if it has sufficient air support, you're going to find that you can completely destroy a circuit court of appeals, not based on the law, but based on just holding these people up to public ridicule, as they should be held up. These people on the 10th Circuit, I don't know how we got so lucky. This was actually Diane's idea. She's looking at this thing one day and says, you know, you think the Almanac of the Federal Judiciary should be looking at it? You know, be my guest, okay? Now, here, so what we did was we looked at the judges who issued this ridiculous decision overturning the earlier decision saying that whoever doesn't mean whoever, all right? I'm just going to give you a handful of quotes on some of these characters. Here's Stephen Hale Anderson. He's a former trial attorney for the tax division of the U.S. Department of Justice. I know a lot of people are going to love that. And here's what the Almanac has to say. Now, these are quotes from lawyers, all right? They're not quotes from people like me who are basically on the outside looking in or in the bowl looking up saying, please don't flush. He tends to be pro-big business and pro-prosecution, pro-government. He's attempting to take over the 10th Circuit and having some success. You know what to expect from him. He adopts the government arguments. This guy's got no business on the bench. Here's another one. Most lawyers interviewed, this is Bobby R. Baldick. Most lawyers interviewed did not rate Baldick's ability very highly. He hasn't thought out the issues. He's not one of the bright lights on the bench. He doesn't care about the Constitution and constitutional protections. He's very pro-government. In civil cases and in criminal cases, if there is a way to rule against a human being, he will do it. He's so pro-government that you don't ever want to have a criminal defendant in front of him. Then the next one, Mary Beck Briscoe, former United States attorney. Next one is Judge Wayne Brorby, former county and prosecuting attorney. Here's what the lawyers say about him. His ability isn't good. I think it's poor, especially in criminal matters. I wasn't impressed with his ability at all. He wasn't prepared, and he was very short-sighted. In criminal cases, he seems to be less patient and less courteous. He's very pro-government. He's very conservative and prosecution-oriented. He tends to side with the government. His opinions are adequate, but not scholarly or intellectual. I think his opinions are poor. I don't think much of his writing. Bear in mind, these are lawyers saying this, all right? Here's Michael R. Murphy, one of these characters. He thinks he's the smartest lawyer in the courtroom. Another one, John C. Porfilio, and this guy changed his name for some rude. He was rude, and I've never had a judge be impolite to me in all the years I've practiced. Now, normally these lawyers are polite to each other, even when one of them's wearing a black dress and the rest of them are standing down looking up. You imagine what he's going to do to you. He was extremely impolite. He didn't like the position I was taking on behalf of my client. Instead of realizing I was trying to be the best advocate I could, he took it personally. I have been troubled, this is the last one here, by his opinions in terms of the outcome and in terms of the depth of his analysis. The analysis wasn't there, and the outcome was inconsistent with other opinions of this circuit. In other words, more legal anarchy. These people rule by the seat of their pants, not according to law. This is, let's see, Judge Dinelle Reese-Taka, pretty hard on criminal appeals. Her writing is average, and basically there's nothing good. They don't say anything good about her. And here's the lawyers' comments about the 10th Circuit. In other words, this is the circuit on the overall. The quality of legal scholarship there is largely disappointing. They are always one-upping each other. Now, come on, is this a circuit court of appeals or a boys' club? There are a lot of little hoops that they want you to jump through to perfect your appeal. There are a lot of traps for the unwary. The 10th Circuit is a discouraging place to be for a plaintiff's case or for a criminal defendant. Plaintiff would normally be civil rights, Tucker Act, RICO, federal tort claims. You don't want to be a criminal defendant in front of this circuit because they are so conservative. They are very conservative, especially in criminal cases. They tend to be pro-government. In civil rights cases, the 10th Circuit is deaf. They are openly and arrogantly hostile to plaintiff civil rights cases. If you lose in the district on either a criminal or civil rights case and you appeal, you're in big trouble. I think they are result-oriented and intellectually dishonest. I can't repeat this enough. These are lawyers saying this. They love qualified immunity, but otherwise they are very, very bad for criminal defendants. They're prosecution-oriented. It's a pretty restrictive circuit and not a good circuit for the criminal defendant. You can always find a case to support your position. There are lots of opinions for the opposite proposition, and they don't get reconciled very well. I'm not a big fan of the writing of the 10th Circuit. I don't think they write opinions that are concise statements of the rule of law as they see it. The opinions are not as good as you'd like to see. If you are looking for superior appellate opinions, this is not what you would like to see. Their opinions are not as intelligent as some other circuits. Now, I cannot stress this enough, people. These are not only lawyers who are saying this, these are appellate attorneys. These are the guys at the top of the heap. These are the guys you sit down with. The guy says, yeah, I'll go through your transcript. You know, you were in trial for a week. I'll look at your paperwork. Write me a check for 25 grand, okay? These are the guys at the top of the heap. And this is what they say about this circuit. And if you go back and read this particular case, what you're going to find is that these people are fruitcakes. They're worse than the normal fruitcakes. And they've made some serious mistakes because some of the people they've been shafting. See, one of the reasons that the federal judiciary has gotten away with screwing the rest of us for so long is basically they've been shafting the peasants. But what I've run across in the last couple of years is one fellow that they shafted. Okay, the guy's name is Noah Robinson. You've probably never heard of him. All right. Another guy has personal friends in the White House. They cost him $53 million, and he's out to get even. All right, and I'm coaching him. Okay. There's another fellow that's the #2 stockholder in Media Bypass magazine, and I'd like all of you to be on the lookout for Media Bypass next month because there may be a photograph of a federal judge on the cover with judicial tyranny right above his head, and an article by yours truly explaining what a scumbag he is. Okay. Incidentally, for those of you who never heard of Noah Robinson, anybody here hear of his brother, Jesse Jackson? Okay. In other words, these people have made some serious enemies. And I want to give you one thing here before we go to the, there's two things I want to give you here before we go to the next part. First is I want to give you a quote from a fellow who wrote a book on appeals. It's at the top here of page 44. And this summarizes what happens in the appellate process. In many, many cases, what used to be a trickle has now become a flood. There are also available, especially to a court of last resort, certain thoroughly illegitimate leeways of action which can buttress or cover unreckonable deciding. Thus, the flat ignoring of authority in point, which is technically controlling, the presentation of prior cases as if they held what they do not, or did not hold what they did, the ignoring or outright twisting of vital facts in the record in hand, and the like. The horrible thing here is that unwillingness to face up to responsibility for needed change in law or inability to discover and phrase a broadly solving rule can, in a good case, lead even an upright and careful court to blacken the judicial shield by such procedures. The book was written 39 years ago, and the guy would practice primarily back in the 40s and 50s. Now, if you look here, there's an appendix here, there's an order, because part of this complaint addresses the order where this fellow got shafted in the district court, so we did feel it necessary to include this one as an appendix because the complaint in chief addresses some of the fraudulent reasoning in this particular district court's order, which of course will be upheld in the 10th Circuit unless we smack them first. Now finally, on the Singleton holding, the reason this last page is in here from Title 18, Crimes and Criminal Procedure, you'll also find that in this blue book right here in the footnotes, is that the primary holding when the Singleton decision was turned upside down by the whole 10th Circuit is that whoever does not apply to employees of the Department of Justice. In other words, that's their holding. Well, there's a fellow here, if you look in the lower right, that says the exact opposite. Way back in the early 1960s, you might recognize the name. He was the Attorney General of the United States, Robert F. Kennedy. And basically, when you read these two paragraphs, you're going to see that's precisely what this statute was intended to address. Okay, now, anybody has any questions, line up here now. If you don't have any questions, I'm going to go on to the next set here. I'm going to go on to Larry Boland's RICO. Okay, I don't see anybody. Now, this is the 11th Circuit. How many people here are from the 11th Circuit? Show of hands. 1, 2, 3, 4, 5, 6. Okay, good. The 11th Circuit, the way they do things is they don't read anything. And what they do, I believe I mentioned this yesterday, is the 11th Circuit has a habit, and Hatchett, the chief judge there, was honest enough to admit this. Of course, I'm going to tell you a little story there. The 11th Circuit has staff attorneys in Social Security, black lung, and pro se cases who will take your brief. They will take a brief that's 50 pages long, and they'll make a one-page summary of it. And in that one-page summary, they will basically say, okay, this is what this case is about. This is what this guy's argument is, all right, even though it isn't. Now, I don't know about you, okay? I've been in this racket for 25 years, off and on, okay? And what I don't quite understand is how someone can take a 50-page brief where somebody has gone through up to 6,000 pages of transcript, which is what you get in a 6-week trial, framed all the issues very carefully, made all his points. I do not understand how some staff attorney can take that particular brief, summarize it in a single page or a half a page, put it in front of a 3-judge panel, and give an accurate summary. Because, see, here's the problem. Not only do I think they can't do it, I think they won't do it, because think of yourself. Let's say you were a staff attorney, and you're working up there. There's like 43 of these creatures in the 11th Circuit at the moment. They have an authorized strength of 47. 20 years ago, they had an authorized strength of 0. The judges did all the work. All they had was law clerks, which they still have, and court clerks. You take these people from the big law firms, okay? Here's a staff attorney. Now, he knows he's not going to be there forever. He doesn't have lifetime tenure like the judge does, and actually, judge isn't there for lifetime tenure. That's not in the Constitution. It says good behavior. If they were actually held to that standard, there wouldn't be one of them left standing tomorrow. But think about this for a minute. You got a staff attorney, and of course, he's looking to make forward motion in his career. And here comes this lawsuit. And here's this housewife from Florida who's never going to do him a bit of good. And here's the big Holland and Knight law firm that has 450 employees all across the United States, a big outfit. And you're saying, okay, let's see. I read this brief here and I read this brief here, and it looks to me like, you know, the housewife should get it, but I need to kind of feather my own nest here, so I'm just going to slant this just a bit so that I know the judges will rule against her. And so that's what happens. And then the next thing you know, this staff attorney is working for Holland and Knight. I mean, it's about as crooked a situation as you can imagine. And this went on for a number of years. I coached Peggy Daddick through her first RICO back in '93. We lost it in the 11th Circuit. And when the ruling came back down, I said, Peggy, this is just gibberish. This doesn't make any sense. And a couple of years ago, Peggy is the one who discovered that these people are not reading anything. And then when she went to this Commission on Structural Alternatives, the United States Court of Appeals, that's where she was sitting there listening, and that's where this thing came out. And you'll see it in the paperwork here in your book. You will see that, obviously I have to flip a few pages here to get to where I'm supposed to be, all right? You'll see that what actually was happening and what has been happening, and they've admitted it, is that staff attorneys are making summaries. I mean, it's right there in a transcript in which there was a panel from Congress on this thing. There's another couple of people here. In fact, I'm going to have to cover this right after the break. But one of the things that you can look at where it says when you get a ruling back from an appellate court, it says do not publish. Normally it means you're entitled to it, but we're going to screw you anyway. 15-minute break, and we'll be back on deck.
And we are the Irwin Rommel School of Law, and our address is P.O. Box 211. I just forgot where I live. P.O. Box 211, Atwater, Minnesota. The Babylonian commune number is 56209-0211. Our phone is 320-857-2400. Our dedicated fax 2401. And our World Wide Web address, http://members.aol.com/Rama-Law. We're going to take a short break, and we thank you.
Okay, we're going to do a case analysis. We only have about 4 of them here, so it should be fairly brief, but I'll try to be thorough. And actually, I don't have to be that thorough because a lot of this stuff's pretty simple. First one is wife culpable for withholding financial info about business when not reported on personal return, which distorts overall picture of business I purchased from her husband, which was originally in corporation. His wife sat in on multiple meetings and never offered the info when requested by purchaser. Well, what the purchaser's recourse to do here is... You did.
Now it got discombobulated. Now we can hear you.
Okay. All right. The proper remedy here is you sue the husband for fraud, and then you just name her as a conspirator, an accessory for aiding and abetting, all that sort of thing in this particular fraud. Okay? Church receives donations from international, it looks like missions, sent collections to International Trust to multiply through asset management as the Lord provides, share the increases with its members, citations from the Bible. Okay? Government seized all accounts because of SAR from Union Bank. I don't know what an SAR is, but I'm sure it's a piece of paper. Got 1.8 suspicious activity report, okay. Got 1.8 million in all records and computers, now using grand jury via Secret Service to investigate. Numerous lies have been told by agents to witnesses. Okay, when an agent tells a lie to a witness, that's obstruction of justice. Title 18, Section 1503, it's also a felony. For Title 18, Section 1001, they use it against us. We never use it against them because most of us don't know about it. IRS did audit for 1995, even though something paid Social Security, took all records, $50,000 plus demanded. We filed Bivens. They motioned to dismiss. We moved to strike their motion. Well, somebody else is handling this. I'm not familiar with this case, and the one thing I will not do is I'm not going to get in the middle of somebody else's legal work. I don't care whether it's an attorney, a paralegal, a fruitcake. That's none of my business, okay? Plus, see, since I haven't seen the Bivens, I haven't seen the motion to dismiss, I haven't seen the motion to strike, obviously the amount of information that I have on this, whatever I told you, would be wrong. Here's another one. A person's property was seized but received no notification as required by rules and regulations of the IRS. And join the club. A civil forfeiture was filed and was later converted to a criminal forfeiture. What next? Well, I'm familiar with this case, and this particular case is in your book, so I'm not going to address it either. Okay. Here's the next one. Now, this is what I was trying to warn you about yesterday. IRS officer violated my rights, bankruptcy protection, state and federal laws, and IRS rulings. When you say somebody violated your rights, people, that's a conclusory allegation. That is not a fact, okay? That is a statement of opinion. That is a conclusory allegation. Claiming non-existent authority, unreasonable seizure of property, well, you know, depends on who's defining unreasonable. Compelling me to be a witness against myself in a criminal investigation, okay? We're all the way down to here. I'm not going to mention the fellow's name. There's not a single fact here, people. This is how you lose cases. You've got to tell the facts. In other words, if you say I was driving down the road and the State Highway Patrol violated my rights, what does that tell us? On the other hand, if you say I was driving down the road, State Highway Patrolman came up behind me, came up to my side of the vehicle, busted the glass out, opened the door, dragged me out, beat the living crap out of me, that's a series of facts, okay? District courts denied fair hearing, conclusory allegations, denied discovery, how, doesn't say, falsified record, doesn't say, appeals court answered questions not asked, that surprises you, okay? What you've got here is you've got an entire piece of paper without a single fact on it. And I'm not saying this to be impolite or trying to be mean to this individual, but remember, I'm not here to make you feel nice about yourself. This is the legal equivalent of special forces, and if you get bruised going through the course, if you don't like wading in blood up to your chest, that's just the price you pay to learn this. And what I hope this individual learns from this is that this is not how you write something, okay? These are nothing but opinions. They're conclusory allegations. You file anything in court with this kind of stuff, these courts are hard enough to deal with as it is, but when you file this kind of stuff, they're impossible. Peter Simpson, you have something to say?
Yeah. The thumbnail of all of this is a statement of facts is who, what, where, when, and how. You may not address the question why. It goes to motive, it's conclusory, and it's inadmissible. The secret to legal writing is you draft the thing out as long as possible. You then break it into one-sentence paragraphs. You then go through each sentence and remove every adjective. And then, remember, in a statement of facts, besides no conclusory allegations, no legal claims. So he defrauded me is not a fact, it is a legal claim. So just remember, who did what to who, when, where, and how. No why, no adjectives, no conclusory allegations, no legal claims. Thank you.
Peter, have you got Katie's case here?
Yes, we do.
Hold it up. Okay, now, the reason Peter can speak with such authority on that
is because I am guilty.
Yeah, back about 8 years ago, and you think, this poor guy here, you think I'm getting on your case? It took Peter Simpson and 2 other individuals, all right, 3 weeks to come up with a statement of facts, because everything they did was conclusory allegations. And the only reason that I exhibited so much patience with him is because every time I went over to his house when he lived in Springfield, his wife fed me breakfast. She's a pretty good cook. Okay, other than that, I'd have flushed him years ago. And here's the worst part of this, all right? I'm working with 3 of these characters for 3 weeks to get a lousy 150 paragraphs of facts, and they wore me out. and believe it or not, those of you who get a copy of this, they still got 2 conclusory allegations past me that are still there.
They're still in here. We truly wore them out. It was Larry Lewis, an associate of ours who's now in Idaho, and it was the inimitable Mr. Rogers, who will close our seminar this afternoon, and I. And it's true. It took, from front to back, starting, it was almost 6 weeks. They tape recorded Larry and Dwayne interviewing Beverly and I. And I think we presented Michael with 6 separate statement of facts. And the first one was an astonishment to behold. In our business, we do what we call red line. And 1 sentence per paragraph. The reason you do that is when you give it to a researcher or a freelance consultant, what he does is any paragraph that does not apply to the case gets a red line through the first word. Then when the researcher goes over it again, as soon as he sees the red line, he just skips it because he knows he's not going to deal with it at all. So we also, Billy Kimbrough called them lineouts, where you just start eliminating the crap. And the first one absolutely looked like some kind of a bizarre, new art thing. It was black and white with red everywhere, red slashes everywhere. And it was quite complex. Michael has suggested in previous seminars that you deal with an English major and you lay it out for him and have him write it. It's really not that hard. It does take some practice. Who, what, where, when, how, no why, no conclusory allegations, no legal claims. Safest thing for you, no adjectives. And that's how you do statement of facts. It's covered in pretty extensively in our Dallas and Charlotte seminars, which are in our catalog. Michael?
Okay, and this is not an uneducated man either. He's got a college degree, but boy, when I got that statement of facts, all I could think of was, oh, what a headache, because there were no facts. It was just all allegations, all right? Let's get back to Larry Boland's case here against the 11th Circus. There's a do not publish here, paragraph 41, page 8. And I want to take you down here to paragraph 42. The do not publish, I'm going to show you here in a minute because I've basically flipped through here so I'd get a little better organized during the break. Now, this is a master docket entry. I'm sure all of you will recognize it by now because you all know how to read that. Order by Magistrate Judge John R. Strother, Jr. as to defendant Lloyd Barry Thompson, directing clerk to shred sealed material. You can't do this. This is an obstruction of justice act right here, and there's the entry date from 97. I mean, this guy should be going to the pound for this. One of you people walk in a court, get some sealed material, take it out and shred it. What do you think is going to happen? They'll drop the courthouse on you. Now, what I was telling you about, go here to page 11, okay? And here's Chief Judge Hatchett, and here's what he's saying. How much can we delegate to law clerks and to staff attorneys, and how much can we fail to have oral arguments, and how many opinions cannot be written before a circuit is not doing a good job? All right? And he goes down here, and you go over to the next pages, and he's talking about all these things they're doing. And the funny part of this is that at the time he was saying this, see, a little story here. The way we found out about this Commission on Structural Alternatives, it was supposed to be open to the public. Well, we had a little guy down in Atlanta named B.J. Uchin. And B.J. Uchin one day was reading a law newspaper. And he saw this little tiny notice down on one page about the Commission on Structural Alternatives, and he reads this, and he calls Peggy Daddick. Peggy says, I'd like to see this. And that's where all this came from. It was ostensibly open to the public. It's just that the public wasn't notified. Nothing on TV, nothing on the radio, nothing in the newspapers. Only in a legal newspaper, which of course is only going to be read by lawyers. And of course, no lawyer is going to go up against this system because that's where they feed. Lawyers normally don't crap where they eat. Okay? Now, if you go here to the bottom of page 13, you see Peggy Daddick's name and what she's saying about these people, and she's talking about the security. This is worth reading because it tells you what happens to a lot of things in the circuit courts of appeals. It's not that the judges don't misrule, it's just that people go up there, lawyers go up there, and if they're up against a pro se litigant, they destroy records. Now, what this is doing, a lot of this, one of the main civil rights issues here is denial of access to the courts, and they can deny you access in more than one way. In other words, they don't have to just park a tank outside They can deny you access to the courts by not reading your pleadings. That's what Larry was complaining about here in this RICO. Here's a quote here. This is on page 16. Go to the single-space paragraph, number 64, all right? In Chambers versus Baltimore and Ohio Railroad Company, the Supreme Court recognized this right of access, and we're talking about access to the courts, in the context of a diversity tort suit. Tort means from tortuous or crooked conduct. In other words, it's an action